Alright, Federal Motor Carrier Safety Administration, Subpart E decisions. 38661 decision. Administrative law judge after the receipt of the proposed findings of the fact, conclusion of the law, arguments of the party, administrative law judge shall have an issue a decision. Proposed finding of fact, conclusion, law, and arguments with the oral, and he or she may issue oral decision. Decision of administrative law judge becomes final decision of the associated administrator 45 days after it is served, unless the petition or motion of review is filed under 38662, but the decision shall be served on all parties with the assistant administrator. Hearing officer. The hearing officer will prepare a report with the assistant administrator containing findings of the facts, recommended disposition matter within 45 days after the conclusion of the hearing. The assistant administrator will issue a final agency order adopting the report, making such the determinations appropriate. The assistant administrator's decision to adopt hearing officer's report must be reviewed in accordance with the 38664. 38662 review administrative law judge decision. All petition review must be accompanied by exemptions and briefs. Each of the petition must set out the detailed objection to the initial decision, shall state whether such objects of the related to or alleged errors or law of fact. It also state that the relief of the requested failure to object to any of the error initial decision shall waive the right of the alleged for the types of error of subsequent proceedings. Reply briefs may be filed within 30 days after the service of the appeal brief. No other briefs shall be permitted except upon the request of the assistant administrator. Copies of all the briefs must be served on all the parties. No oral argument will be permitted except in order of the assistant administrator. 38663 decision of review. Upon review of the decision, assistant administrator may adopt, modify, or set aside administrative law judge findings and fact, conclusions, laws of law. He or she may reprimand the proceeding of the administrative law with instructions for such for the further proceeding he or she deem appropriate. If not reprimanded, and the assistant administrator shall issue the final order disposing of the proceeding served on all parties. 38664 reconsideration. When 20 days following the service of the final agency order, any of the party may petition an assistant administrator for the reconsideration of the order. If a civil penalty was imposed if the filing petition was reconsideration, stays on the entire action until the assistant administrator orders otherwise. Alright, in the event of the notice of the default final agency order with the issue of the field administrator and result of the responding failure to comply with the reply with the accordance with the 38614A, only the issue of the concordance considered for the reconsideration, whether the default of the accordance or under 38614C. The final agency order may be vacated with the responding demonstrated excusable neglect, meritorious defense, and due diligence seeking relief. Either party may serve an answer for the petition reconsideration within 30 days of serve the day of the petition. Following the close of a 30-day period, the assistant administrator will rule on the petition. Ruling of the petition will mean the final agency will be the final agency order. Petition for the reconsideration assistant administrator ruling will not be permitted. 38665, failure to comply with the final order. And within 30 days of the receipt of the final agency order issued under this part, respondent does not submit the writing and his or her acceptance of the term and order directing compliance with the appropriate pay with a civil penalty on file appeal with 38667 may be referred to the Attorney General with the request of the action brought with the appropriate United States District Court to enforce the terms of the compliance order or the collective civil penalty. 38666, motion of rehearing of the modification. No motion of rehearing for the modification of an order shall be entertained for a year following the day of the assistant administrator order goes into effect. After 1 year after the party with the file of the motion, assistant administrator requesting a rehearing and a modification of the order, the motion must contain the following: a copy of the order which for the change is requested, a statement of the change circumstances justifying the requesting, and copies of all the evidence intended to be relied on. Party submitting with the motion. Upon receipt of the motion, assistant administrator may with the decision denying the motion of the modifying order in whole or in part. He or she may also, prior to making his or her decision, order or such of the other proceedings under the rule he or she deems necessary, to may request additional information from party making motion. Alright, 38667. Judicial review. Any party underlying with the proceeding of the after the administrative injunction or advisedly affected by the final agency order issued in Title 49 U.S. Standard Code 521 may, within 30 days of the service of the final agency petition with a review of the order of the United States Courts Appeal and Circuit where the violation is alleged to have occurred when the violator has its principal place of business, residence, or United States for the appeals of the District of Columbia Circuit. Alright, judicial review will be based on determination whether the finding of the conclusion final agency order was submitted, supported by substantial evidence wherever the otherwise not in accordance with the law. Of no object that has not been raised before, agency will consider the court unless the reasonable grounds existed for failure or neglect to do so. The commencement of the proceeding under this section will not use it unless ordered by final court operate the state of the final agency order of the agency. Alright, so Part F, Injunction Imminent Hazard, 38671, Injunctions. Whenever it is determined the person engaged is about to engage in any of the practice of consulting in violation of 31502 of the Title 49 United States Code of the Motor Carrier Safety Act of 1984 as a Material Transportation Act, any of the regulation or order issued under this section, those actions over which Federal Motor Carrier Safety Administration exercises enforcement responsibility, Chief Counsel may request of the United States Attorney General to bring action with the appropriate U.S. District Court for the relief of the necessary appropriate, including mandatory prohibitive injunction relief, interim equitable relief, the cumulative damages provided with Section 213C Motor Carrier Safety Act of 1984 and Section 111A of the Hazardous Material Transportation Act or Title 49 U.S. Standard Code 507C 5122. Imminent hazard. Whenever it is determined that the imminent hazard exists as the result of the transportation of motor vehicle with a particular hazard material, the Chief of Counsel of the Deputy of the Chief of the Counsel of Federal Motor Carrier Safety Administration may bring the request of the United States General to the bringing in action of the appropriate United States District Court for an ordering of the suspending or restricting the transportation of motor vehicle with a hazardous material or for such other order is necessary to eliminate merilated imminent hazards as provided in Title 49 U.S. Standard Code 5122. The paragraph of the imminent hazard meaning for the existence of the condition of the presence, substantial likelihood of the death and serious illness of the severe personal injury or a substantial endangerment to the health of the property environmental may be order occur before the notice of the investigation proceeding, other administrative hearing, of the formal proceeding to abate the risk of the harm to be completed. Whenever it is determined the violation of Title 49 U.S. Standard Code 31502 of the Motor Carrier Safety Act of 1984, amended to the Commercial Motor Vehicle Safety Act of 1986, as amended or regulation issued under the Section Act of the combination with such violation proposes imminent hazard to the safety of the Director, Office of the Enforcement, complying with the Division Administrator, his or her delegation shall order. A commercial or motor vehicle with an employee operating with a sensor vehicle out of service of the order employer to cause cease all other part of the employer's commercial motor vehicle operations are provided in Title 49 U.S. Code 521B5. The intermodule equipment provided with a specific vehicle or equipment out of service of the order with the intermodule equipment provided to cease all part of that operation provided in Title 49 U.S. Code 521B5 and Title 49 U.S. Code 31151A31. In making such order, no restriction shall be imposed on the vehicle, the terminal facility, employer, intermodule equipment property provider beyond the required abatement of the hazard. In the paragraph, imminent hazard means a condition for the vehicle, the intermodule equipment employee with a commercial motor vehicle operation substantially increases the likelihood of the serious injury or death and discontinued immediately. Upon issuance of an order with the under paragraph B1 of the section, motor carrier employer with the intermodule equipment provided with the driver employee shall comply with immediately with such orderly or such an order opportune with the review of the provided in accordance with the Title 554, except for such review shall occur no later than 10 days after the issuance of an order with the provided within Section 213B of the Motor Carrier Safety Act of 1984. An order on employer intermodule equipment provider for the case cease all of the parts for the operation shall not prevent vehicles to transmit time and order and serve within proceeding with immediate destination unless any of the vehicles with the driver specified under order out of service with and however the vehicle's driver proceeding with the immediate destination shall be subject to the compliance upon arrival. For the purpose of the section, term immediate destination for the next scheduled stop of the vehicle are already motion with the cargo on board and can be safely secured. Failure to comply immediately with an order issued with this section is subject to the motor carrier employer and intermodule equipment employer of the driver penalties prescribed in subpart G of this part. 38673 Operation Services Record Consolidation Proceedings Reincarnated Carriers. Out of service order of the Federal Motor Carrier Safety Administration Field Administrator or Director of Field of Federal Motor Carrier Service Administration Office of Enforcement Compliance Director may issue out of service order to prohibit the motor and intermodule equipment to be provided with the broker, a freight forwarder with a conducting operation subject to the Federal Motor Carrier Safety Administration jurisdiction by determination of the field administrator, the director of the motor carrier, intermodule equipment provided for the broker of the freight forwarder, an officer with employee agent authorized representative of such entity operative that attempted to operate motor carrier, intermodule equipment provided for the broker and freight forwarder under the new identity affiliated entity. 1. Avoiding complying with the Federal Motor Carrier Safety Administration. Avoid complying with the statutory regulatory requirement. Avoid paying a civil penalty. Avoid responding to the enforcement action. Avoid being linked with a negative compliance record history. or record consolidation order. In addition to and in lieu of the out of service of the order issued within the section, field administrator, the director of the issue may order consolidation records maintained with the Federal Motor Carrier Safety Administration concerning the current motor carrier intermodule equipment provided with the broker, freight forwarder, its affiliated motor carrier intermodule equipment provider, and broker, freight forwarder, or its previous incorporation of the purpose of the determination of motor carrier intermodule equipment provider, broker, freight forwarder, or officer or employee of the authorized representative of the same operative with attempt operate a motor carrier intermodule equipment provider, broker, and freight with the forward using the new identity as affiliated identity, avoid complying with the Federal Motor Carrier Safety Administration, avoid complying with the statutory regulatory requirements, avoid paying civil penalty, avoid responding to enforcement action. 5. Avoid being linked to negative compliance history. Or the stand, the field administrator of the director determines that the motor carrier intermodule equipment of the provider of the freight, broker, freight forwarder reincarnated with a substantial continuity between either one of the merely cancellation of the other. Field administrator of the director may determine the motor carrier of the intermodule equipment that provided with the broker, freight forwarder, and affiliate with the broker business operation under the common ownership of the common control, making the determination of field administrator of the director may consider among the 10 things of the following. When the new affiliated was created for the purpose of evaluating evading the statutory regulatory requirements of Federal Motor Carrier Safety Administrator order, enforcement action, negative compliance history, and weighing with the factor of the field administrative director may consider the stated business purpose of the creation of the new affiliated entity, purpose of the entity, safety of the performance, including among this of other things, the safety violations, enforcement actions of the secretary, if any. 3. Consideration exchange with the assets purchase and the transfer date with the company criteria of the dissolution and cessation of the operation commonality of the ownership of between the current and former company between current companies, commonality of the officer and management personnel, identity of physical or mailing address, telephone number, fast mile, email address, identified motor vehicle equipment. Continuity of liability issuances, insurance policies, commonality coverage relief under the policy, commonality of the drivers and other employees, continuation of the commercial carrier facility, other physical assets, continuity of the commonality, nature, scope of the operation, including the customer from whom the transport is provided. 13. Advertising corporate name and the other acts of which the company holds itself out of the public. Evaluating effective field administrative directive of the examiner of the among other things, company management structure, financial record of the corporate file and records, asset purchase, transfer, list, title history, employee records, insurance records, any of the other information related to general operation and entities involved in the factors, paragraph C of this section. Alright, E, effective dates. In order to issue under this section become the final agency order effective within the 21st day after the serve until the request for the administrative review is served and set forth in paragraph G of this section after the motor carrier intermodule equipment, the provider for the broker, the freight forwarder, and the fails to comply. Alright, effective dates when order issued that under the section become the final agency order in effect of the 21st day of the serve and left the request for the administrative review is served. Followed and set forth in paragraph G of the section and motive of the carrier intermodule equipment of the provider, broker of the freight forwarder with the fail to comply with the prohibition requirement that set forth in an order to issue within section subject to the applicable penalty provision for each of an instance of non-compliance, commencement of the proceeding with the field administrator of the director of the May with the commencement of the proceeding under this section and issuing that order that provides notice of the factual legal basis for the order in the case of the out of service the order and enough of the operation prohibition by the order in the case of ordering the consolidated records maintained by the Federal Motor Carrier Safety Administration and enough of the previous with the currently affiliated motor carrier intermodule equipment provided brokers, freight forwarders who the records will be consolidated, provided notice for the order is effective the 21st day after service. Provide with the notice of the right of the petition with the administrative review of the order of the timely petition with the stay with the effect of the day of the order with unless for the assistant administrator of the order of the otherwise good call with the provide the notice of the failure to timely request administrative review and order of the constitute with the waiver of the right to consent with the order and while resolve of the order becoming the final agency order 21 days after the serve of administrative review. A motor carrier intermodule equipment that provide with the broker freight forward with the issue then order with the under the section with the petition with the administrative review of the order. A petition administrative review is limited with the contesting factual procedural errors in the issue with the order under the review that may not be submitted with the demonstration of the corrective action. A petition with the administrative of the review that does not identify the factual procedural error of the issue with the order of the review of the dismissal of the petition seeking with the demonstration of the corrective action to do so submitted in the petition of recession under the paragraph H of this section. Petition Administrator for the review of the writing of the service of the Assistant Administrator, Federal Motor Carrier Safety Administration, 1200 New Jersey Avenue, Southeast Washington, D.C. Attention Adjunction Council for the Electronic Mail, FM Federal Motor Carrier Safety Administration, adjunction@.gov. Copy of the Petition Administrator review of the service on the field, Administrator of the Director of the issue of the order, physical address of the electronic email account if ordered. A Petition Administrator of the review of the must be served with the 15th day of the day of the field, Administrator of the Director serve of the order issued under this section. For a timely request of the Administrator review the waive the right to the Administrative review and the constitute of the admission of the facts alleged in an order. Petition for the Administrative review must include the copy of the order, dispute with the statement of all the factual procedure issued, the disputes, and petition for the Administrative review the timely serve of the file with the petitioner with the supplement of the petition, serving documentation, evidence, written argument, the procedure for the factual issue that is not in dispute no later than 30 days after the disputed order with the serve of the supplementary document, evidence, of written argument that may not expand issue for the review need does not address every issue identified with the position, failure to timely serve the supplementary documentation evidence of the written argument to constitute the waiver of the right to do so. Field Administrator Director serve the written argument with the subject of the supporting documenting evidence for the defense of the disputed or with no later than 15 days following the period of the position may serve the supplemental documentary evidence or of the written argument in support of the position administrative review. The Assistant Administrator may with all the parts substantial additional information attended to the conference facilitate administrative review. So the Assistant Administrator will issue the written decision, request for the Administrative review within 30 days of the code of the time period with the field Administrator, the Director for the serve of the written argument with the supporting document evidence for the defense or of the actual filing of the search for the argument and the documented evidence of whichever is less or earlier. And the Position Administrative review the timely serve within accordance with the subsection disputed with the order stayed within pending of the Assistant Administrative review. The Assistant Administrator may enter in an order vacating automatic stay within accordance with the filing procedure. Agency official may file with the motion vacate the automatic stay with the demonstrated good cause why the offered order shall not be stayed. Agency official must be in the writing of the state the factual legal basis for the motion accompanied with the affidavit or other evidence relied on based and be served on the Position Assistant Administrator. Alright, 2. The petitioner may file with the answer for the opposition accompanied with the affidavit or evidence relied upon. The answer may be served with the 10 days served with the motion. Assistant Administrator will be the decision motion vacate with the automatic stay with the 10 days closed for the time period for the serving the answer for the motion. 30-day period for the review of the Position Administrator review in the paragraph of G7 of the section told from the time of the agency official motion for the lift to stay with the serve of the Assistant Administrator issued the decision of the motion. The Assistant Administrator decision of the Position Administrative review of the order is issued of the section constituted with the final agency. H. Position or recession, motor care with the intermountain equipment to provide with the broker the freight forward with the main position for the resign and order of the issued under the section in action that is taken the corrective deficiencies of the result of an order. One position of the recession must be made with the written with the field administrator of the director who has issued an order. Petition of recession must be included with a copy of the order request of the resigned and in factual statement of identified with all the corrective actions taken the copy of the supporting document. Upon request of the good cause shown with the field administrative director may grant the position or additional time not to exceed 45 days to complete the corrective action initiated at the time of the petition of the recession for was filed. The field administrator of the director will issue the written decision on the position resignation within 60 days over the service of the position. Written designation will include the factual legal basis of the determination. Field administrator of the director of the grant for the rescissions of the written decision of the final agency. If the field administrator of the director of the denies request the rescission of the petitioner may file a petition for the administrator review of the denial with the assistant administrator, Federal Motor Carrier Safety Administration, 1200 New Jersey Avenue, Southeast Washington, D.C. Detention Adjunction Council with electronic email, Federal Motor Carrier Safety Administration adjunction.gov. The petitioner administrator review of the denial must be served with the file within 15 days of the serve of the decision denied with the request of rescission petition from the administrator that must identify the disputed factual procedural issue with respect to the denial position. The rescission of the petition may not file, however, the challenge an underlying basis for the order with the rescission of the sought. The assistant administrator will be written with the decision petition or administrator review of the denial of the position resignation within 60 days. Assistant administrator decision constitutes federal final agency order. Alright, other orders are unaffected. The motor intermodule equipment provider broke up the freight forwarder subject of an order issued under the section become the subject of any of their prohibition requirement. The Federal Motor Carrier Safety Administration order with the issued under the section. In addition, it's not amendment to supersede each other order prohibition or other requirement. Motor carrier intermodule equipment the provider broker freight forwarder subject to an order with the issued under the section remains subject to the suspension revocation Title 49 U.S. Code 13905 violation of the regulation governing their operations and the applicability of the subparts B, C, D, and E of this part, except for the 38667, do not apply with this section. Alright, subpart G, penalty, 38681, to the general. The amounts of civil penalties can be as if the regulatory violation subject to the proceeding with the subchapter established in the statutes granting and enforcement powers. The determination of actual civil penalties is set for the proceeding with the base of these defined limits of the minimum of the consideration information available at the time of the claim that is made with the concern with the nature of the gravity of the violation, respect of the violation, degree of the culpability, the history of the prior offense, of the effect of the ability to continue to do the business, such as other matters of justice, public safety may require the addition of these factors. Civil penalties are set for the Title 49, 14, 901 A and D concerning household goods based on the degree of the harm caused by the shipper, whether the shipper has been adequately compensated before institution of civil proceeding of the injunction of the claim of the order under the administrative procedure herein. Additional information may be developed regarding these factors and that may affect the final amount of claim. When assessing penalty with violation notices, order settling based on these assessment consideration will give them faithful to achieve the compliance of the terms notice from the orders. 386, 82 for civil penalty violation notice for orders. Additional civil penalty chargeable violation notice for the orders issued under civil forfeiture proceeding of this Title 49 U.S. Code 521B. Notice and orders are filed with notice to abatement 38611B2 NC14. Notice to post 38611C3. Final order 38614, 17, 22, and 61. As for the order 38672B1. A schedule of these additional penalties are provided in Appendix A with the part of the penalties of the maximum discretion with them will be retained with the maximum circumstances of penalties violation of notice orders in some cases less than the maximum stated claims and penalty provided in section Appendix A of this part made through the civil forfeiture proceeding with the contained within this part of the decide with such proceeding is limited to whether the violation notice the orders of the claim with the appropriate penalties such violation nothing contained with the start of the construed authorized reopening of the material matter already finally adjudicated under this part. Alright, 386, 83, civil section failure of the pay with the civil penalty of the payment of the operation of interstate with commerce. General rule: the common commercial motor vehicle owner of the operative field of the civil penalty of the full within 90 days after the date is specified of the payment by the Federal Motor Carrier Safety Administration. Final agency order that prohibited the operating interstate with the commerce for the starting of the next. Prohibition continues until the Federal Motor Carrier Safety has received the payment of the penalty. Intermodule equipment that provide with the fails to pay with the civil claim within 90 days of the date specified with the payment of the Federal Motor Carrier Safety Administration. Final agency order is prohibited with the tendering of the intermodule equipment the motor carrier for the operation of interstate with the commerce of the operating of the next 91st day of the prohibition of the continue with the Federal Motor Carrier Safety Administration receive full payment of the penalty. Alright, 2. Civil penalties and installments of the Federal Motor Carrier Safety Administration service time that may allow with the commercial motor vehicle owner and operator with the intermodule equipment that provide with the make of the civil penalty installment of this commercial motor vehicle owner and operator with the intermodule equipment that provide with the fails to make with an installment of the payment of the schedule of the payment plan avoided an entire debit and payable immediately. Commercial motor vehicle owner and operator of the intermodule equipment provided with fails to pay the full outstanding balance of the civil penalty 90 days after the date of the installment. Payment is prohibited for the operating in an interstate with the commerce for the next 91st day of the prohibition continues until Federal Motor Carrier Safety Administration receives the full payment of the entire penalty appeal with the federal court if the commercial motor vehicle owner and operator of the intermodule equipment provided with the appeals with the final court, final agency order, federal circuit court with the appeal of the terms of payment due with the date of the final agency order or not stated unless the court says so directed. Show cause of proceeding. Federal Motor Carrier Safety Administration will notify the commercial motor vehicle owner and operator of intermodule equipment provided with a written with the notice of the written that has not received written in writing that did not receive the payment within 45 days of the specified payment of the final agency order of the day missed installment of the payment of the notice will include the warning of the failure to pay with the entire penalty within 90 days if the penalty was due. Result of the commercial motor vehicle owner and operator of the intermodule equipment that provided the being prohibited from operating in interstate commerce. The notice of the order will the commercial motor vehicle operator of the intermodule equipment provider should cause the show have been shown not prohibited for the operating in interstate commerce on the 91st day specified in the payment of the prohibition may be avoided only by submitting the chief safety officer. Evidence of the respondent paid for the entire amount. The evidence of the respondent filed with the bankruptcy under Chapter 11, Title 11 of the United States Code. Responding in bankruptcy must also submit the information required in paragraph D of this section. The notice will be delivered with a certified mail and the commercial express service at the principal place of business. The commercial motor vehicle owner, an operator, and an intermodule equipment provider in a foreign country. The notice will be delivered with the designated agent of the commercial motor vehicle owner and operator, intermodule equipment provider. Commercial motor vehicle owner and operator with the intermodule equipment provider with the continue to operate interstate with the commercial violation section B subject to additional sections on paragraph 4 of I of 1 appendix A of part 386. Alright, this section does not apply to any of the person when unable to pay the civil penalty because the person is a debtor of the case under the Title 11 of the United States Code, Chapter 11, the commercial motor vehicles owner and operator and amounts equipment provided by the bankruptcy proceeding within Chapter 11 to provide most of the following information when they are responding to the Federal Motor Carrier Safety Administration. Chapter Bankruptcy Code with which the bankruptcy provides proceed is filed with Chapter 7 and 11, the bankruptcy case number, the court with which the bankruptcy proceeding was filed, any other information requested of the agency to determine the debtor's bankruptcy status. Alright, 386-84. Sanction failure to pay the civil penalties for abatement with a plan of suspension, revocation, registration. Generally, the registration of the broker, the freight, and forward or hire motor carrier, foreign motor private carrier if it fails to pay the civil penalty within 90 days after the date specified the payment of the Federal Motor Carrier Safety Administration final agency order will suspend starting on the next day of the 91st day of the suspension. Continue with the Federal Motor Carrier Safety Administration has received full day payment of the penalty. Civil penalties paid in installment of the Federal Motor Carrier Safety Administration. Service Center may allow respondent broker of the freight forward for hire motor carrier, foreign motor private carrier to pay civil penalties in installment of the respondent fails to make the installment of the pays the schedule of the payment plan is void with the entire debt with the payable immediately with the registration. Respondent fails to pay remainder of the civil penalty full and within 90 days of the day of the administered installment of the payment, then suspended the next 91st day of the suspension continues until the Federal Motor Carrier Safety Administration has received full payment of the entire penalty. Appeals to the federal court. The respondent broker the freight for hire motor carrier, foreign motor private carrier. Appeals via agency, federal court, circuit court appeals, and the terms and payment due to the final agency order not stated unless the court shows directs. If the court so directs. Alright, showing cause proceeding them in Federal Motor Carrier Safety Administration over the break of the freight with the award for hire motor carrier with the foreign motor private carrier with the writing and with the receipt of the payment with the 45 days after the specified with the payment with the final agency over the day of the misspent all of the payment. Notice will include the warning of the failure to pay the entire payment and penalty with the 90 days after the penalty due to the result of the suspension of the respondent registration. Notice will order the respondent to show the cause of the registration not suspended the 91st day after the day of the specified the payment. The prohibition may be avoided only by submitting safety chief and the officer evidence responding to the pay of the entire amount. The evidence of the respondent and the file with the bankruptcy under Chapter 11 and Title 11 of the United States Code. Respondents in bankruptcy must also submit the information required in paragraph D of this section. Alright, 3. Notice will be delivered to certified mail with the commercial services of the respondent principal place for the business. Foreign country will deliver to respondent to the designated agent. Your registration broker freight forward for hire motor carrier, foreign motor private carrier that continues to operate the interstate commerce violation of this section after registration has been suspended may be revoked and additional notices of opportunity proceeding in accordance with the Title 49 U.S. Standard Code 13905C. Additional sanctions imposed within paragraph 4 of the 1 of the Appendix A, Part 386. D. This section does not apply to any of the person unable to pay civil demand because the person is a debtor in the case of the Chapter 11, Title 11 of the United States Code. Brokers and freight forwarders for hire motor carriers, foreign motor private carriers, and bankruptcy proceeding in Chapter 11 must provide following information from the response Federal Motor Carrier Safety Administration chapter of the Bankruptcy Code under the bankruptcy proceedings, bankruptcy case number, the court in which the bankruptcy proceeding was filed, any other information requested of the agency to determine the debtor's bankruptcy status, and Appendix A, Part 386, penalties and schedule violation notices and orders. And I skipped all the appendixes, but this has been, that concludes the Part 386, Rules and Practices of Federal Motor Carrier Safety Administration Proceedings.